when you are asking your question. So when you are asking questions, you must yourself be very calm and very clear. So it's important then that you ease the witness, that you relax the witness, and establish clearly the surrounding circumstances in which each witness must testify. Why is this important? The introduction and the background and all of those things, the context. Because you want to give the court a broader picture of what you are dealing with. And then after that, then you can direct the witness to current events. So you take him back, you deal with the current, which are introductory issues, then you take him back to the events at that time. But also, as you are dealing with examination in chief, you must also have your ear on the record, because whether you are the state or you are the counsel for the accused, there is this potential or possibility of being able to appeal. So keep your eye on the record. But one thing that you must do as counsel by all means necessary is to try and be as comfortable, be as natural as possible, spontaneous, and allow the witness to tell their story. Allow the witness to tell their story, and to tell their story the way they know it happened. And do not try to look like, in all respects, that you are reading from your book, or you have a script that you wrote everything down, and in court then you are just really reading. Because you need to connect not just with the witness, you need to connect with the judges also. So when you happen to read, you lose the eye contact, you lose a lot of people. So I would say it's important that you do not read. It's important that you be fully prepared. Go through your questions a couple of times so that you can flow with the events. Because sometimes you can prepare your script, but when you are busy leading, the witness can take you somewhere where you never maybe anticipated, but that could be beneficial to the case. And so that is why be natural, stand engaged, look at the court, look at the witness, and be as natural as possible. Now, one of the issues is that you must have confidence in yourself as counsel, and obviously you would have ensured that you select the right witnesses, disregarded the wrong ones, and ensure that the material that you are dealing with is relevant, and that you present everything in a logical order. You know, judges are human beings, and judges really, they know that we have prepared, they know that we consulted, they know that we probably have questions prepared. So it does not mean when I say you must be as natural as possible, you must neglect your preparation, because you'll do it as naturally as possible, but sometimes you might forget what you wanted to get out, and then you can always revert back to your notes, but not as a norm. So that is also a good thing. But also, you must understand there are certain dynamics when you are dealing with witnesses, part of which is that there can be a long period that passes from the time the case was opened to the time the trial starts. And with the passage of time, memory becomes also a problem. So what we want is a situation where we as counsels must understand that the human mind is problematic when it comes to memory, and that people can forget certain things, and that is reasonable. And that when you are dealing with particular issues, a witness might forget certain aspects of the case or of the testimony that you wanted him to bring across. You are aware, he is not aware, and your job is to ensure that you are able to extract that information from him, but without leading that witness. And when you see that the witness has forgotten something, you can't just leave it. You must try to intervene and prod his memory. Find a way to prod his memory, and then, because you are the one that is facilitating the whole thing on behalf of the state. So that's important. And one of the issues, and this is very difficult for counsels, is that we tend to get emotionally attached to cases that we are dealing with. And by all means, the more you are emotionally attached, the more your clarity of mind escapes you, because emotions now cloud your judgment. So try to be as disconnected to the client's case as possible. And really, the truth is, sometimes the witnesses just don't remember. And sometimes there are underhand issues that also occur when it comes to these issues. But at the end of the day, the idea is you can also try to remind the witness. And as you remind the witness, he remembers something that you wanted him or her to remember, but then forgets other things that were also equally important. So just find a way to deal with these things. Now, there will always be those scenarios where there are unexpected things that you are dealing with that are also important. And at the back of your mind as counsel, you must always understand or ask yourself questions. Why I consulted you? Remember, you consulted with them, they gave you certain answers. Sometimes in court, they give you different answers. And you must always ask, why is this person answering me in this way or giving me this particular response? And that is very important. And think very fast. Was it an error or was it an intentional issue? And if so, what should you do? Because sometimes there's something that you realize that your witness is doing wrong, but you are not sure whether the counsel for the opponent has picked it up or not. You see, you are not sure. So if you highlight it, you bring it to their attention, which then later they can use in cross-examination, and you don't want that. But the danger also is there is information that is damaging to your case that you now have brought up, and it is better that you clarify it than you allow your opponent to clarify it. So when you come across those type of situations, it is better then that you yourself clarify that particular problematic area and do not allow your opponent to do it, because it can be very bad. So if you know the reason for the mistake and that it can be rectified, then try to put the question or to phrase the question in a different manner so that you can at least correct it or clear it in the eyes of the court. And that's important. Some of the ways we can go about doing this is we can ask direct questions. These are questions that draws attention to a specific issue. And obviously an answer will be required, and because sometimes, for example, you get into a situation where you ask a leading question, but with that requires you can get a yes or no question, yes or no answer, but without the explanation, it's not really material because it does not extract anything. So you could always ask the question, for example, in a way to say, was something like this discussed, right? Then you can probably say yes or no. But even if they object, there's no answer that you suggested, isn't it? Because he has to explain the issue, you see. And only through the explanation does the leading question become really then a direct question that you can extract something from. The important issue is that as counsel, you must ensure that the material that you are giving or presenting does not provide information or material for your opponent to cross-examine your witness on. And this is very important. And one of the things that is also important is that people tend to be sometimes very problematic in court because they maybe volunteer too much information, or you ask them a simple question and now they give a 10-hour response, and that is basically unnecessary. You must always train your witnesses to only answer the questions that they are asked and provide answers to questions that they are asked. Now, because if you don't do that, you will get into a serious problem. So do not allow your client or your witness to volunteer points in chief, because you cannot control them, because you don't know if he volunteers the information, where the information will ultimately go. But at the end of the day, depending on the type of information that is also being volunteered, you can decide on the merits of each of the points or whatever that's being addressed, whether or not there is a need, to deal with that issue. But the important thing is volunteering the point in chief rather than running the risk that the points is raised in cross-examination is lesser and thus preferable of the two evils. So it is better that if your witness was flamboyant and now has volunteered things that would benefit your opponent, it is better then that you try to address that issue, the demon in the room, so that your witness can clarify it by the time your opponent comes in cross-examination, there's already clarity in the eyes of the court. So sort your own difficulties out before you leave it for cross-examination and they cause damage to your case. But lastly, my friends, I think one of the important issues as we've gone through the leading of evidence or examination in chief is that once you've gone through all these drills and you've sort of provided a clear direction in terms of how one goes about leading, important considerations of leading, extracting the essence, realizing that essence, or knowing the plan that you have for your case, knowing what you want, knowing why you want it, but more importantly, knowing how to extract it at the end, and you've gone through the whole process. Lastly but not least, you must ensure that you double check that you've covered everything. It is very, very important that you must make sure that you have dealt with all the material points or issues that were necessary or that you required from that particular witness. And with each witness that goes by that you deal with, make sure that they have covered the things that you wanted them to cover. And this is very important. And when you realize that the witness has forgotten something, and then try to prod the memory, it's allowed. So there is no problem. Now, there are certain things that are important, is that if there is like an omission in terms of an important fact, then you will have to prod it. And then you must remember, do not put a leading question or a question that assumes a fact not yet established or that assumes a particular answer. And once you also maybe the witness forgot something and then you start afresh and you try to help them remember, they might equally forget other things. So that is also a danger that we have. But also you can have a situation where your witness now is very confused or provides or it seems that the recollection is very vague, and that can look damaging in the eyes of the court. And this is something that you as counsel must ensure that you get clarity. And then so you can always indicate when to try and sort that out, to say, but was something said about something like this, or was this point and this point canvassed, or whatever the case might be. So having said that, friends, that is more or less the gist of what goes on into an examination in chief, important considerations that we need to deal with. And I hope that with this small video, you have now the theory, and more or less in practical, not in practical, but in theory, more or less clarity of how you need to go about doing it. And then remember the list of the questions that are leading questions and the list of questions that are not leading questions. For your case in examination in chief, you must exclusively deal with non-leading questions. So thank you very much for taking time to listen to this lengthy video, but I promise you it is not a waste of time. It is something that if you just would listen to this video and you pay attention to what I'm saying, it will help you a long way in effectively telling the story of your witnesses and ensuring that all the elements of an offense are proven and that you are able to deal with issues much more naturally, with much more confidence, without shaking in the presence of your counterparts. So thank you very much for listening, and I am looking forward to the next video. Hopefully we'll be dealing with cross-examination, who knows, anything, anytime, depending on how I'm feeling. So thank you very much and enjoy.